Welcome to annual general meeting series. Today we are discussing service of AGM, notice, proxy, attendance slip and practical compliances. Complete FAQ mode. So welcome back to our AGM Masterclass Series. In part 3A we have discussed the AGM notice under section 101 of Companies Act 2013. And in part B we learnt about the explanatory statement under section 102 of Companies Act, the difference between ordinary business and special business, and the importance of disclosing material facts. So today we are going to discuss another practical topic, that is every company secretary must understand how an AGM notice should be served, who should receive it, what constitutes a valid service, the concept of proxy and the attendance slips, and the requirement of route maps wherever required, and the practical requirements under Secretarial Standard-2. So many companies prepare an excellent AGM notice but fail to serve it properly. So a defect in the service of a notice may give rise to disputes regarding the validity of the meeting. So let us understand this topic through a practical FAQ mode. Why is the service of AGM notice is so important? The answer is, friends, preparing AGM notice is only the first step. The second and equally important step is to ensure that it is served and every person entitled to receive it. The law does not merely require the company to prepare the notice, it requires the company to give the notice in the prescribed manner. So if an eligible member does not receive the notice because of the negligence on the part of the company, the member may question the validity of the proceedings. So the company secretary should have a robust system for dispatching and recording the service of notices. Which provision governs the service of AGM notice? The service of notice is governed primarily section 101 of Companies Act 2013, notice of general meeting, and section 20 of Companies Act 2013, service of documents. So the company's management and administration's rules 2014 and Secretarial Standard-2 issued by ICSI, and the articles of association of the company, SEBI LODR regulations in the case of listed companies. So a company secretary should ensure compliance with all these provisions while dispatching the notice. Who should receive the AGM notice? The AGM notice should send to every person who is legally entitled to receive it. This generally includes every member of the company, joint holders of the shares as per the Act and articles, legal representative of deceased members wherever applicable, and assignee or insolvency representatives wherever applicable. So every director, the statutory auditor, the secretarial auditor wherever applicable, debenture trustees or other persons if required by law or the articles. So the company secretary should verify the register of members and the statutory records before dispatching the notice. Then what are the modes of serving of AGM notice? The Companies Act permits the service of AGM notice through various modes, including registered post, speed post, courier service, hand delivery, electronic mail, that is email. Any other e-mode as recognized under the Act and applicable rules. In today's corporate environment, electronic communication has become the preferred mode, especially for the listed companies. Can the AGM notice be sent by email? Yes, the Companies Act permits the services of the notice through electronic mode, subject to applicable rules. So the notice may be sent to the email address registered by the member with the company or the depository participant. Electronic service offers several advantages: faster communication, lower cost, environment friendly process, and then easy maintenance dispatch records. And these are all the advantages. So however, the company should retain proper evidence of email dispatch for future verification. What is meant by proof of service? Proof of service means the evidence that the company has dispatched the AGM notice in accordance with the law. Depending on the mode of service, proof may include postal receipts or courier acknowledgement, email dispatch reports or delivery confirmation or dispatch register, certificates issued by service providers. So maintaining proper proof of service is a good governance practice, and it particularly useful during secretarial audit or regulatory inspections. So what is proxy? Proxy is a person authorized by a member to attend and vote the general meeting on the member's behalf, subject to the provisions of the Companies Act. Proxy need not necessarily a member of the company unless the articles provide otherwise. The appointment of a proxy enables the members who are unable to attend the AGM personally to participate in the decision-making process through their authorized representative. What rights does a proxy have? A validly appointed proxy may attend the AGM and vote in accordance with the authority granted by the member. However, the right of a proxy are subject to the Companies Act and the Articles of Association and the terms of the proxy appointment. Company Secretary should verify the proxy forms before the commencement of the meeting to ensure that they are properly executed and received within the prescribed time. What is an attendance slip? The attendance slip is a document enclosed with the AGM notice to facilitate smooth registration of members at the meeting. It generally contains the name of the member, folio number or DP ID, client ID, number of shares held, signature column, details of proxy or authorized representative wherever applicable. The attendance slips help the company to maintain an accurate attendance register of the meeting for the meeting. Why is roadmap attached to AGM notice? As per the Secretarial Standard, the AGM notice should contain route map to the venue of the meeting if it is a physical meeting. The purpose of route map is to enable the members to locate the venue easily if it is a physical meeting. Although many companies now conduct meeting through electronic means, so wherever permitted, only physical meetings should generally include a route map to facilitate the attendance. Who can represent a body corporate at the AGM? Where a member is a company or any other body corporate, it may authorize any individual to attend the vote at the AGM on its behalf of passing any appropriate board resolution or issuing an authorization in accordance with the law. So he has to carry the authorization. Similarly, the President of India or Governor of State or other statutory authorities may authorize representatives wherever they hold shares in the company. The Company Secretary should verify the authorization of the documents before permitting such representatives to participate in the meeting. So what are the common mistakes committed while serving AGM notices? Friends, during secretarial audits, the following mistakes generally be observed. Incorrect calculation of the notice period. Clear notice, 21 days, clear days. It means excluding the day which we are sending the notice and date of the meeting. Sending notice to outdated email addresses, another mistake. Failure to dispatch notice to the auditors or directors. Non-maintenance of proof of dispatch, another mistake. Defective proxy forms, another mistake. Failure to attach the explanatory statement, another mistake. Omission of the route map if it is a physical meeting. Incorrect e-voting instructions, other mistake. So such errors can be avoided by preparing a comprehensive compliance checklist before dispatch. So what are the responsibilities of the Company Secretary regarding the service of notice? The Company Secretaries plays a crucial role in ensuring that the AGM notice is served correctly. The responsibilities include finalizing the list of the eligible participants, first eligible recipients, shareholders and recipients, verifying the postal and email address, and supervising the dispatch process, maintaining proof of service, coordinating with the registrar, RTA, registrar and transfer agent, wherever applicable, ensuring compliance under Secretarial Standard, at least SS-2 and the Companies Act, preserving records for inspection and future references. So my practical tips are: before dispatching AGM notice, verify first board approval has been obtained, and then the notice contains all mandatory particulars. Check the explanatory statement is attached wherever required. The correct notice period has been calculated. In the fifth one, the list of the recipients is updated. Sixth, proof of dispatch will be preserved. Seventh, proxy forms and attendance slips are enclosed. Eighth, route map if it is required, and e-voting instructions are included as per the applicability. So a small oversight at this stage may lead to unnecessary disputes later. So dear friends, today we discuss the practical aspects of the serving of AGM notice under Company Act 2013. We understand the legal provisions governing service and the various mode of dispatch, proof of service, proxy, attendance slips, route map, representatives, and the responsibilities of the company secretary. So these procedural requirements are not merely formalities. They safeguard the shareholders' rights and strengthen the corporate governance. So in my next video, the next part, we will discuss remote e-voting under section 108, voting at AGM, poll, show of hands, electronic voting, appointment and duties of the scrutinizer, declaration of results, and related Secretarial Standard-2 requirements. So please do attend. In my next video, we'll discuss at length. We have two channels, RR Corporates, other channel RR Legal Talks. Please do subscribe, hit the bell icon so that you will not miss my latest videos. Thank you.